Today's question comes from Appleton, Wisconsin, and the reader asks the following. My mother has investments registered in her name with me as a transfer on death beneficiary. Because she is advanced in age and recently confined to a nursing home, and two older sisters are causing trouble, Mom and sisters are advising me or warning me to get those assets away from her revocable trust. To my understanding, my assets are not actually in her trust since I am the sole beneficiary. Would some type of irrevocable trust be in order, or simply a separate revocable trust which could be protected somehow from her creditors? Her current trust mentions that the proceeds are not accessible to beneficiaries or creditors. She does have long-term care insurance, and that should start paying soon for 5 years. She is a fairly healthy 94 years young. So, great question, and you've got a lot of facts going on here. I'll attempt to go through them as much as I can in a short video. If you're the payable on death beneficiary of certain investment accounts, then those accounts would pass by contract to you upon your mother's death. So that's the part regarding the transfer on death account. However, if alternatively those assets are tied to your mother's trust, then they would be distributed according to the terms of the trust. So whatever the trust says is where they will go. It is important to find the exact information for these accounts and determine how they are titled to know if they're going to pass according to the trust or according to the beneficiary designations. Now, you mentioned long-term care insurance. If your mother is in the nursing home and she anticipates needing Medicaid assistance to help pay for her nursing home care, then you should not transfer any assets without seeking the advice of a qualified estate planning attorney. There's a 5-year look-back period for any asset transferred for less than value when a person needs to obtain Medicaid. So if your mom were to change some of this stuff now or gift assets to you, it could disqualify her from receiving Medicaid for a certain period of time. Now, you mentioned she has long-term care insurance. That sounds like it runs for 5 years. Because she has that, you may be able to do some planning with the assets while you have the long-term care insurance to pay for her care. And as to your last question, a revocable trust will no longer protect your mother's assets in the state of Wisconsin. Generally now you need to use an irrevocable trust, and that date changed August 1, 2014. Some trusts before that date, the state of Wisconsin said they would not go after assets in a revocable trust, but they said after that date they will for estate recovery. And a revocable trust doesn't work if you're trying to qualify for Medicaid. So if you're looking at asset protection options, I would discuss an irrevocable trust with the attorney you talk with. Again, I would look at using that long-term care insurance for 5 years to allow you and your mother to do some asset protection planning if that's what she chooses to do. So great question, and thank you for asking.